Hello, is anybody here yet? If so, let me know in the chat. We're going to get started with the Notice of Procedural Safeguards, Part 2. And so today I am going to be talking about the Notice of Procedural Safeguards, and we'll keep working through the document. First of all, about me, I'm not an attorney. This isn't legal advice. I'm a non-attorney representative and special education advocate in Texas, although I do help kids in other schools in other states. I'm a COPA member and speaker, a member of the Learning Disabilities Association and other organizations. So I bring a lot of different areas of expertise to the presentation. I'm the first advocate to win a due process hearing without an attorney, and I'm all over the state. I've advised in multiple states as a parent liaison and negotiated lots of settlements. So if you were in part 1 or you attended the part 1 webinar, you will know the Texas Notice of Procedural Safeguards. Often this is black and white, but if a school district has enough money to print it in color, they'll give you a color paper copy or a PDF. So the issues with this document are, and you probably don't need me to say this, but they're plucked directly from the statute. The Notice of Procedural Safeguards is generally confusing because it is full of legalese. And so parents don't typically look at it. If they do, they glance at it and don't really read the content. And hopefully that's why you're here today, so we can go through it. So the learning objectives for today are to explain your parent rights, to understand the verbiage in the document, and then be able to use this information when you're in an ARD meeting for your child. So what we're going to cover today is parental consent, procedures when disciplining children with disabilities, and confidentiality. These are all very important, as they all are very important things to understand and be able to reference when you talk to a school district. Does this sound like fun? I hope it does. We're going to have fun today. So, parental consent. So, when is it needed? What does informed mean? What does revoking consent mean? And what attempts does the school district have to take to obtain it from you, the parent? So parental consent is generally needed before an initial evaluation. So what is meant to happen is when you request an evaluation, the ARD committee or 504 team or the LSSP sit down with you and they ask you, what are the areas you suspect your child has a disability in? And this is where you need to be very forthright and very specific about what you think, where you think your child meets eligibility. So the informed piece of consent is not just simply signing a form. It's the school coming to you and saying, okay, we're thinking about evaluating in these areas. what do you think about that? Do you want additional areas? So for example, if your child has been having behavioral issues, then you would ideally ask them to do a functional behavioral assessment, ask them to do some behavior rating scales, those types of things. So there are a few other areas where parental consent is needed. So for providing initial special education and related services. So let's say the school is proposing special education placement. When you go to that initial eligibility ARD meeting, they will ask you to consent for placement in special education. Now, this has got really muddled recently in this area of Texas. And what the schools are doing is they're saying, if you don't agree with the full individual evaluation and you ask for an IEE, then we're not going to put your child in special education. So really that's another violation, because in Texas, there's such a thing as non-consensus implementation, and they have to provide services that you don't agree with. But actually providing parental consent for special education is not the same thing. So you have to provide your consent for that. You also have to, if you want to revoke services, you have to give consent. So you have to write to them and say, I'm giving permission for you not to provide services anymore. I don't want my child in special education. So I have for odd member excusal, this is in red because it's not mentioned in the Notice of Procedural Safeguards. I recently had a parent from California who gave me their child's IEP, and at the top, the actual document says, have any of the members of the ARD meeting been excused by the parent? And that was the first thing on the document. So what's been happening is ARD committee members show up, they're in a Zoom meeting, and then halfway through they say, okay, I need to leave now. I have a class. And the parent doesn't know anything about it, and they let that person go. And then they subsequently regret it because they've got questions further on in the ARD meeting. So the ARD members, if they want to be excused, they have to get written permission from the parent, and the school has to be in agreement. So it's a formal thing. You have to get written permission not to show up at an ARD. Now, what can you do instead? Well, you could essentially tell the teacher that you'll accept a written report, or you can meet with them and ask questions and have them write something up in response to those questions, and that can be provided at the ARD meeting for discussion. So that's one way around that. So what are the school responsibilities with parent consent? Well, they have to get your consent for a reevaluation. So when that 3-year mark comes up, or you want a reevaluation sooner, you have to sign consent for it. Now, sometimes schools say, let's do a read. Let's do a review of existing evaluation data. That is not a reevaluation. It can be part of one, but what some schools will do is they'll say, hey, mom and dad, we don't need to reevaluate, do we? We all know he has autism. And the parent says, yes, that's fine. We can just use data from the IEP or from the classroom. And so the problem with that is you're not getting crunchy, hard data from an evaluation to incorporate into the ARD document. And what can happen is you can find that your child has actually regressed on some objective measures. So generally, I advise parents to always get that reevaluation. So parent refusals to consent. So it used to be that schools were told to try and override refusals with due process and, make the parents put their child in special education. They're not required to do that anymore. So if you refuse to consent, they're not going to fight you on it. Now, the opposite isn't true. So if schools refuse to identify or provide, then legally, obviously, they're in the wrong most of the time. And if they use an FIE to decide that your child doesn't need services, then there are some things that you can do. So how can you use this information? Can you use it in an odd meeting? Could you share it with parent groups or in the community? How do you think that strengthens your advocacy efforts? So let's move along to independent educational evaluations. So what is an independent educational evaluation? So every time the school does or conducts an evaluation of your child, you're entitled to a second opinion at public expense. Public expense means that the school is paying for it and it's provided at no cost to you. So if you don't even have to state why you don't like the evaluation, they usually ask. It may be that it was done correctly, but the recommendations are really horrible and you don't think that they're appropriate, so you want better recommendations. But whatever the reason is, you have a right to one. And so what you usually do is you send in a request to the special education director, and you make the request by saying that you want all areas that were evaluated by the school. And if you think they missed areas, you can put those in too. So it doesn't just have to be for evaluations that they did. And one of the things that I'm seeing lately is they say, well, we didn't do that yet, so you don't have the right to an IEE on it. Well, that is not true. And there's a letter for that. It's called Letter to BOUS. And that letter was written in response to a school district asking that very question. And basically, the assumption is the school had their chance to do something fully comprehensive and they didn't, so they don't get another chance. Now, one of the things to note is recently there's been some bad case law on functional behavioral assessments where a hearing officer found that, or it was actually a circuit, one of the circuits, they found that a functional behavioral assessment wasn't really an assessment. So the attorneys here know that. And so what you need to do to protect yourself is you need to ask for that functional behavioral assessment as part of the evaluation so that it's not separate, it's not an additional assessment, and it's not a standalone. So that is one thing to ask for. Some school districts won't do them as part of an assessment, and so you need to really fight for that in your evaluation. So public expense, again, at no cost to you. Public expense means the public school is going to pay for it. And what that means is usually they take you out of the equation. They contract directly with the provider. The provider has to have the same qualifications as the person that does the evaluation in the public school. So sometimes that might mean that you got a speech evaluation and you need to go find a speech language pathologist to do it, a private one, and you need a private licensed psychologist, That's usually they are LSSPs, so they do keep up the school licensure as well as school qualification. So you're going to have to find people that make up that evaluation team with the same qualifications. So what happens next after you've requested that independent educational evaluation? So what happens is, at disagreement, you send the letter in, and there are two things to take into account. The first one is that the school, maybe they don't respond to you, and you keep sending them emails, and you send them emails for 3 weeks, and they say, well, we haven't made a decision. That is what is called unnecessary delay. So schools are required to send you the criteria letter and where you can get the evaluation without unnecessary delay. And 3 weeks is a long time. So 2 weeks is probably reasonable, but after that, they're delaying the evaluation. So you should tell them that. Now, unreasonable delay covers the entire time frame. So if you have a contract in play that keeps going back and forwards and the school isn't signing it, and they're not getting that in place with the evaluator, then you may have a case for unreasonable delay. What can you do about these two things? Well, you can file for a due process. I've done that. And that certainly lights a fire under the process, because you're going to have a resolution meeting within 15 days. So it's the quickest way to deal with it. Timelines and conditions. So they may not, so the conditions usually are that what we just discussed, the criteria for the person that's doing it. It may be that they've got a geographical radius limit, like they don't want the person to be over 70 miles away, things like that. But they may not put timelines on the evaluation. So if you're given an IEE and you don't set the ball in motion for 5 months, which I don't recommend, but if you didn't, and that's happened during COVID, then you're still entitled to it. There's no clock ticking on that. The other thing regarding conditions is sometimes they look at the reasonable rates in the area, say things like 20% above their prevailing rates, and you might have a dispute over the person that you've chosen, because you can choose someone that you want. You don't have to choose from their list of people. So the criteria letter lays out those types of parameters around who you choose. And additionally, it has a list of where you can obtain one of these IEEs. But again, you don't have to use their list. And you may not want to, because some of the people on there may be school friendly. That's something to investigate. So what happens if the IEE is denied? Okay, so schools can't deny IEEs. And some of the things that happen are they send a prior written notice document to you and they say, well, we don't want to do it. Well, they only have two options, and here are the two options. They have to file for a due process hearing to defend their evaluation, or they have to provide the IEE at public expense to you. Those are the only two options they have. So essentially, if they don't provide the IEE, then you're probably going to have to file on them to get one. So that would be a single issue due process. So what is the difference between an independent educational evaluation, a public expense, and a private independent educational evaluation? So this gets confused a lot. So the difference between one that the school pays for and one that you pay for yourself is the school IEE meets their criteria. So if they've agreed to pay for it, then the person that is doing it has met all of their criteria for an independent educational evaluation. And those criteria include the criteria in IDEA for doing an evaluation. So I always think it's interesting when schools look at IEEs that they paid for and they say, well, we don't agree with it and we're not going to accept the recommendations. It's kind of interesting. A private IEE, on the other hand, is one that you pay for. The person, because it's not being paid for by the school, they don't usually have access to the school property to do the observation piece. So that's the big difference. And schools typically have policies in place where they don't allow private providers on the campus. There are exceptions, but they are rare. And so if you go in with a private evaluation, the ARD committee still has to allow that person in the ARD meeting. I mean, allow either the person in, or they have to consider the private evaluation in terms of the IEP. So they got to look at what's being recommended. Is this something that they agree with? Are they going to put it into the IEP or provide services based on it? So of course, if they decide those evaluations that they're not going to accept them, they have to give you prior written notice and explain why. So here's IEEs ordered by a hearing officer. So in Texas, and any other state, an IEE might be ordered by a hearing officer when you're in due process and an evaluation is found to be deficient. So the hearing officer would basically rule on, is this evaluation sufficiently comprehensive? And if the hearing officer finds that it isn't comprehensive, they might order the district to pay for one. So that is an outcome that you can get. So how can you use this? Oh, additionally, what I would say is if the hearing officer rules the other way, you can still get an independent educational evaluation. You just have to pay, you have to pay for it. And again, that isn't a small thing because these days evaluations can cost up to $5,000 in the Austin area. So how can you use this information in an ARD meeting? Is there something that you can leverage here? So let's move along to discipline. This is a very big section of the procedural safeguards, and there's a lot to talk about. So discipline of children with disabilities. So it always has to be case by case. And this means that when they look at your child's disability and the student code of conduct violation that they're claiming your child violated, then it's got to be case by case and individualized, and take the disability into account. So usually it is over the student code of conduct. You can find that in your student handbook. There's usually a handbook posted on school districts' websites for different levels of students. So you have an elementary, a middle, and a high school handbook. So let's talk about the 10 days of removal. So the 10 days is a really pivotal timeline because 10 days of removal in IDEA is a change in placement, and that triggers other procedural safeguards and rights. So let's talk about those. So 10 days can mean a number of different things. It can mean that your child has been sitting outside the school office for 2 weeks in a row. That would trigger a need for an OD, for an in-school suspension, because that's what it basically, it looks like one, it is one. Or if you're asked to pick your child up over the last month, you've picked them up totaling 10 times, although they might not be consecutive days. If they are essentially for the same behavior, then that would count as a 10-day change of placement. So what are the disciplinary procedures? So first of all, if your child is a child with an IEP, they have to hold a meeting to decide if it's due to their disability, the behavior. So that has to be established. Some schools will insist that it isn't, and they'll say, no, this had nothing to do with their disability. And that usually happens for kids that have ADHD, for example. They try and say that it's something that was within their control. The OD committee has to be involved in the decision making. So we're going to talk about that a little bit. So if your child isn't 10 days yet, then they have to have a meeting. The school does. It doesn't have to be an OD meeting, but it has to be an administrator meeting, so they can try and circumvent that change in placement meeting. So if they say there's no relationship to the disability, then that would happen in a manifestation determination review meeting. And of course, manifestation means it's a manifestation of a disability, and you're reviewing all the documents and all the disciplinary reports and packets and statements that were that this meeting is based on. So you never go to a manifestation determination review meeting without thoroughly investigating the course of events, what led up to the discipline. Of course, if they have a behavior intervention plan, your child has one, then you're going to want to look at that data. So you might do a records request as well. So the manifestation determination review, very important to prepare for this. It has to take place within 10 days. You have to review everything, like I said, and you need to show up with the DSM-5 criteria for your child, because if they're going to make a decision on whether there was a direct and substantial relationship to disability, then they need to be looking at what are the manifestations of the disability. So you can look at what your child did, and you can make a case and tie the behaviors to the DSM. So the school can make 3 decisions. They can make a decision that it wasn't due to disability, that it was due to disability, or they failed to implement the IEP. Now, they're not going to admit to that, but it may be that they weren't implementing the behavior intervention plan properly, or your child needs a behavior intervention plan. So what usually happens at this stage is sometimes schools will say, we really need to change the BIP, or this child really needs a functional behavioral assessment, and that is in the law. So that is what's recommended if there's a direct and substantial relationship to the disability. So at that meeting, hopefully there is proof that it's it's because of the disability. And in that case, there's some negotiation that can take place. Does my child need to be removed from the school into an interim disciplinary placement or not? And so they can only remove your child up to 45 school days. That's a long time to be in disciplinary placement, but it can be reduced. If it's due to the disability, then you can make an argument it's not needed at all. So now 45 school days is automatic under some circumstances. So the school does have the authority to put your child in a 45-day interim placement for these particular offenses. So possession of a weapon. So weapons are defined in the code, and usually it's what you usually think of as a weapon. You know, if there may be some argument, if your child has, you know, a mini nail file or something, that, so for, you know, knives, there are some rules about the size of the knife, that type of thing. But in any case, possession of a weapon is an automatic discipline placement. And so is possession of illegal drugs or sale of controlled substances. So illegal drugs are the ones that you usually think of. I've heard stories about some kids taking their ADHD medication to school and selling it. That's another one. And serious bodily injury. Now, some of these types of conduct violations can result in criminal charges, and some schools have police on the campus, and they may file charges. So, for example, possession of illegal drugs, you got minor in possession. You know, if they've got alcohol, of course, if they're under 18 and under 21 and they have alcohol, then that's minor in possession. It could be minor in consumption. So sometimes these things can result in misdemeanors or, you know, or other charges, more serious charges. So like I said in the beginning of talking about the 10 days, you have to look for patterns. If your child is essentially you're being called to pick him up, you've got to look at half days as well. Do they add up to 10 days? Those all count. And is that behavior similar? Is it for the same reason? So discipline appeals. Here's what you can do if you disagree with the discipline that's being meted out to your child. You can file for due process, and that way you get a stay put in place. We call them stay puts, other states call them pendency. But when you file, your child, essentially their services and placement are frozen. So they're frozen, and so your child doesn't get moved out. Now, the school may file for removal if they think your child is dangerous, so they could file on you. So with discipline and due process, in these cases, you get an expedited discipline process, due process, and it's very much faster than less than half the time of a regular due process. So it's 20 days of the schedule to the due process hearing, and then 10 days for the hearing officer to rule. So very abbreviated, and the resolution meeting has to happen within 7 calendar days. So of course the hearing officer rules on the removal, either agrees or doesn't agree with the school district. And then if you don't agree at that point, you have the right to appeal the decision to district court, which of course is the same as a regular due process hearing. So that's essentially how you get through the appeals process, and it's very quick. So implied protections, this is mentioned in the Notice of Procedural Safeguards. What does this mean? So if the school knew that your child had a disability that probably qualified under IDEA and they haven't evaluated yet, your child has implied protections, the same protections that a child with an IEP has. So that's important to know. So let's say you've been writing to the school with concerns. Oh, Johnny can't read, and his friend can read, and he can't even spell 2-syllable words, and he's way behind, and he's acting out because of it. So you put them on notice that your child needs an evaluation, essentially. Let's say you requested an evaluation. So you requested the evaluation and you didn't hear from them, or the evaluation has started, you signed consent for that. Implied protections kick in for your child if they get in trouble. Well, let's say teachers requested an evaluation from the district. Those are all indicators that your child has implied protections. And so if a child that has a 504 plan violates the student code of conduct, they get the IDEA manifestation determination review. Under 504, they're really treated like gen ed kids. Now, there may be a manifestation determination review under 504 that the school's put in place. But if they expel your child, for example, they don't have to educate him or her, whereas under IDEA, they do. So I was actually able to exit a child from from a disciplinary placement because the school LSSP admitted that he should have had an FIE, and so I was able to get him out. And it was a situation where he would have started high school in disciplinary placement, which is a horrible way to start high school. So we got him out to start 9th grade in general education. So that's how it can work for you in a real life situation. So let's say you didn't tell the school anything about your child, or you said you didn't want an evaluation. That does happen, where parents have said, oh, I want to just keep along with 504. We'll just see how this year works out. And the school has said, no, he needs an evaluation. So they can say, sorry, your kid's going to get treated like a gen ed kid in this case. Or let's say your child has been found ineligible for special education by the district. So typically, this is something you might want to fight, especially if you asked for it. You might want to file. But during that time, your child doesn't have IDEA protections because they're not in special education after that evaluation. So how can you use this information for odd meetings? Well, if your child is being disciplined, it would be a good time to use some of these facts. I don't recommend going to a manifestation determination review without the discipline referral packet or equivalent document. You need time to prepare. It's a serious thing, your child being put in disciplinary placement, and it may be hard to get them out. So they might become a revolving door. And unfortunately, those types of locations are where the school to prison pipeline begins. And some kids get put in there repeatedly and then they drop out of school. So there are all kinds of reasons that you want to take discipline very, very seriously. So moving along now, this is our third section, confidentiality of information. So confidentiality, educational records are protected under FERPA. FERPA is the Privacy Act that covers them. What are educational records? So educational records are not recordings that are taken by a child in a class, for example. They're not anything that isn't a tangible record in your child's file. So that's important to know, because sometimes schools will say, well, your child can't record the class and they can't do this as an accommodation because that would be a FERPA violation. No, FERPA doesn't apply to that. It's not a FERPA violation. So educational records are kept in different places depending on the school district. So what you want to do is you want to request your child's educational records, anything and everything that is contained within it, and you want to review them before an ARD meeting, a resolution meeting, or a due process hearing. So typically, parents don't know this, but when a school says 45 calendar days, that doesn't apply if you have an upcoming ARD meeting. You're allowed to get those records before the ARD meeting. So what I do is I tell parents, set the ARD meeting and then ask for the records, because they have to produce them before the ARD meeting. So it's a good way of getting a hold of your child's records. Now, you can get them also in an expedited way before the resolution meeting, or a due process hearing. But typically, for due process, there's going to be discovery, and that's going to cover records and other documents that are not in your child's file. So what can happen when you ask for those educational records? Some school districts try and confuse a parent's request for the educational file with an open records request. Those are two different things. An open records request is for any document, and not documents that are in your child's file. So let's say you want to look at emails. You could ask for any emails that are in the file, but if you think they're not in the file, then you could ask for, in an open records request, you could ask for emails between teacher X and teacher Y regarding your child over a certain period of time. So that is one way that you can obtain information, but don't muddle them, and the school district will some school districts try and muddle you on this issue. So when you have access, you must have access to the records to review them. Some schools may copy them for you, especially if you need copies. Schools can put them on a flash drive. And the reason I have that in red is it's not mentioned in the Notice of Procedural Safeguards. Some schools put them on a disk. Now, a lot of people don't have computers that read disks anymore. So you may want to provide a flash drive to the part of the district where they're going to be putting these records onto your flash drive. So school districts may charge for copies. That can get expensive. They may not charge for search and retrieval. So finding your child's records doesn't cost you anything. And they do have to interpret the records for you if you ask. And that may be a good thing, because sometimes they put data in there, it's heavily redacted, and you don't really know what it pertains to, if it's part of a test. So ask for interpretation. So confidentiality of information, as part of that, access to educational records. Third parties need your consent. If the school is saying that they contract with Joe's reading service, they're going to have to get your consent. If you want your records to go to an outside licensed psychologist, that you're going to have to sign a release for that. The school's going to want you to sign a release. It's not required for participating agencies, so agencies that are part of your child's special education. If your child's 18, the child has educational rights, so they're going to need the child's consent. And then private school communication and transfer. So if they're transferring to a private school, the information to a private school, they're going to need your consent as well. So appeals for inaccurate records. Sometimes things go into FIEs that shouldn't, and parents want them removed. So a school district put in essentially a misdemeanor, minor in consumption, into an FIE, and the parents wanted it removed for good cause. The school agreed to take it out. Now, if the school doesn't agree to take it out, they have to tell you in writing that they're not going to do it. And then they have to tell you that you have a right to a FERPA hearing at the local level. So that would be like a grievance hearing of some kind in the school district. And if at the hearing they agree to change it, then they have to make a change to the information, and redact it or whatever they're going to do to it. Then the parent has a right to place a statement on the information if that amendment is denied. So you can put a statement on the information if you think it's inaccurate. So it goes into the record, as part of the record. So records destruction. So people ask me about this, what does the school do with my child's records? Well, in Texas, they're required to keep records for 5 years after your child leaves the district. And that's a long time. So the school at that time, at the time of destruction, they can redact all the personal identifiers, so your child's name and names and anything that identifies them, or they can physically destroy it if it's in a physical format, so they could shred it or whatever. And TEA requires that their parents are provided a notice of this destruction, so you should get a notice. I recently had a situation where a parent found out that their child's records had been destroyed while they're still in the school system. And that is absolutely a violation of FERPA. So, and that could be part of a due process or possibly a TEA complaint, because a parent has a right to see their child's educational record and it's been essentially tampered with. So hopefully today I unraveled the legalese involved with these sections of the Notice of Procedural Safeguards. Thank you all for coming, and you can follow me on TikTok and Facebook at Makes Bed Better. And this is my website, my email if you need to contact me. It's info@lumenadvocacy.com. Thank you for attending.